Good afternoon, everybody, and welcome to our webinar on the subject of GDPR, the impact on local government and how to prepare your workforce. Hopefully everybody can hear me. I've seen some raised hands on the right-hand side of the screen. So I'm confident that you can hear me, which is great. You can't hear each other, and there are too many of you, I'm afraid, to be able to talk to us. So we thought that we put you on mute, but there is a facility for you to ask questions over on the right-hand side in the control panel. So if you wish to ask any questions throughout the presentation, please feel free, and we'll pick them up at the end, and then we'll run through the questions and do our best to answer them as we go along. So the whole session we hope won't last any more than 35 to 40 minutes, and thank you very much for taking your time out and joining us. My name's Nick Richards. I'm CEO for Me Learning. I'm the good-looking fellow on the left, and I'm joined today by the equally good-looking fellow on my right, Piers Clayden, who's the partner of Clayden Law. And Piers and I are going to be presenting today. So Piers is going to really be starting off with going through the background of GDPR, why it's a game changer, and the key implications for local authorities. And then Piers is going to hand over to myself, and we're going to talk a little bit more about what Me Learning have been doing and are doing now, and how we think we may be able to help you with this process of getting your organisation ready for GDPR in May next year. So without any further ado, if I could hand over to my colleague Piers.
Nick, thanks very much indeed, and good afternoon everyone, and thank you for joining. So just a quick canter through the background to GDPR, about which we've heard an awful lot just recently. Slightly more complicated. If I'd been giving this talk a week or two ago, I would have just been talking about GDPR, but actually as of last week, the government saw fit to complicate matters by introducing another data protection bill into the House of Parliament, which we are just getting to grips with now, actually. But I will be referring to that in various places through this talk. But to cut a long story short, the effect of that bill will be to make the GDPR apply across the board within the UK in one seamless way. So there will be no distinction between GDPR and non-GDPR activities. It will all be covered by the GDPR. So the GDPR itself is going to come into force on the 25th of May 2018, and my current assessment of the data protection bill is that it will also come into force at the same time. So we will have a seamless data protection regime at that date next year. Obviously, for local authorities, personal data is an absolutely crucial asset, and is intrinsic to pretty much everything they do. And the GDPR is going to have an enormous effect on how that personal data is handled within the organisation. And because of the higher fines that are going to be coming through, or that could potentially be faced coming through from the GDPR, it's important that this becomes a really high-level, executive-level issue for local authorities. Not least because historically we can tell from the fines and the enforcement actions that the current Information Commissioner's Office has brought that local authorities do often find themselves in the firing line for failure to comply with the current data protection regime. The GDPR will, obviously, as I say, apply across the board to organisations large and small. For public bodies, and obviously these include local authorities, and the Data Protection Bill makes it clear that it's anyone to whom the Freedom of Information Act applies, that they will face actually a slightly higher compliance threshold in some respects, I should say, and I will touch upon those a little bit later. Another point to note is that the liability picture has now increased in the sense that adversely affected individuals whose privacy rights have been, as I say, adversely affected by data protection breaches are now going to have a much easier ability to bring action against controllers, data controllers, i.e. local authorities, and their outsourced organisations, their data processors. And whilst many concepts and principles do remain from the current data protection regime, and indeed this has been reinforced by the Data Protection Bill, a lot of the exemptions and exceptions for processing of personal data, which we find in the Data Protection Act, are going to find their way into the new regime through the government's new bill. Many of these principles remain, but there are additional elements coming through from the GDPR and real enhancements as well, requiring, I think, a very different approach to how organisations approach compliance with data protection. So whilst IT and technology will inevitably find itself sort of in the driving seat in trying to achieve compliance, it's really important that there is a lead from the top down and across organisations that there needs to be a joined up approach to achieving compliance by May next year. So looking at now, I'm just going to run through what I feel are the top 5 key implications for local authorities from the GDPR. And the first one I'm coming across is accountability, and this is a really new principle, one of the new principles that comes through in the GDPR. And I think can be summarised very much in the phrase: not only must you comply with the law, but you must also be seen to be complying with the law. And demonstrability is absolutely key to complying with this principle. So at any stage, from a data protection point of view, are you able to show with records, evidentially, that you have done what the GDPR has required? And so various ways in which organisations are going to have to achieve that through quite extensive internal records. Local authorities, a data protection officer will be mandatory for local authorities, so that is an individual who is embedded in the organisation and is able to, in effect, be a sort of guardian for privacy for that organisation. Sorry, for the personal data held by that organisation. You'll be required to show that you've got in place very robust information security measures, and required to show that you are at all times thinking about privacy very much at the forefront of what you're doing, not as an add-on afterthought, but by thinking about it right at the beginning of any new process or activity, and particularly where there's a risk, there's a potential privacy risk to individuals by doing what you're doing. You'll be required to carry out a data protection impact assessment before you start carrying out that particular activity. So, in terms of how do you actually go about, starting to think about achieving this particular requirement, clearly you need to know where you are at the moment on your sort of data protection journey, in order to know how much further you've got to go to get to the top of the mountain, which is the GDPR. And so obviously one of the ways we can do that is to do a data protection audit, which throws up any sort of gap analysis between your current position and the sort of higher benchmarks required by the GDPR. Ensure at all times that you've got clear records of your data processing activities, and indeed where processing is being carried out with the consent of an individual, do you have the records to record that consent? Ensure that you've got your data protection officer up and running in good time for May, so that that they are not having to sort of get up to speed on the 24th of May next year. And make sure that your workforce are fully up to speed with their new roles and responsibilities under GDPR. And obviously, one of the ways that can get achieved is through training, and of course that is where the Me Learning offering can prove to be invaluable. Also, to what extent can you take advantage of any existing codes of conduct or external certifications to show your compliance? For example, ISO governance is a way of at least showing, although it does not map exactly onto GDPR, it is a good way of showing that you are undertaking best practice from an information governance point of view. So next key implication is around consent, and organisations have must only process data legally, and to do this legally you have to satisfy one of the grounds for processing, one of the bases for processing. One of these grounds is the consent ground, so an individual has given its consent to processing, and that is obviously widely used at the moment by organisations, but the benchmark or the hurdle for consent now is now higher than it was, and the regulation requires that consent should be freely given, specific to the processing activity being carried out, informed and unambiguous. And the new point, and the point I think which is going to be difficult for local authorities sometimes, is the freely given point, because of the imbalance in power between the local authority and the individual. You know, requiring someone to consent to a certain type of processing before you action an application that an individual may have at the authority for a certain type of processing. That sort of consent is now possibly not going to be valid, and it is an issue that local authorities are going to have to come to terms with. How can they validly process people's personal data when the consent ground is no longer available to them? The statement, the consent has to be a clear affirmative action or statement. So, unfortunately, those pre-tick boxes that we're all quite used to seeing and probably ignoring in our daily lives will no longer cut the mustard, nor will silence, and nor will sort of inactivity. So that is that's another area that we'll need looking at. We now know that under the bill, the definition of children from a data protection point of view is now anyone under 13, and so parental consent is going to be needed for processing for processing for anyone under that age. And the other point about consent is that it needs to be clearly stated to the individual that they can revoke it as easily as they have given it. So just coming to the next slide. And we've heard a little bit already about the sort of high level of fines that the Information Commissioner is going to be able to levy for non-compliant organisations. And failure to get the right consents in place and failure to process data in a legal way will attract a higher level of fines, a tier 1 level of fines, and that is the 4% of turnover, 20 million euro fine. So in terms of what to do, action points, obviously, you know, where consent is an issue, you need to look at the current validity of those consents. How were they gained in the first place, and do they need to be sought again? You need to be able to keep a record of exactly how and when that consent was given, and you need to have in place processes that deal with consent withdrawal. And from a public authority point of view, I do counsel rather, you know, looking at alternative basis for processing, and these might be, for example, performing a contract with the individual. There may be a legal obligation to do the processing, protecting a person's vital interests or other public functions. One of the big call-outs for public authorities under the GDPR is that the legitimate interest grounds, which was the ground, you know, an often used ground for showing valid processing, will no longer be valid, no longer available for public authorities. And of course, sensitive personal data processing there, when it's consent-based, it needs to be an explicit consent, which is an even higher level from the current consent. Coming on to the next point, bearing in mind that local authorities invariably do end up outsourcing some or many of their functions, it's just worth noting that there's a new regime in relation to this particular area. For the first time, data processors, i.e. the outsourcing organisations, will be subject directly to the GDPR. That's not the case at the moment, but it will be from May next year. And so that may lead you to be, well, that's great, because that means that if they're liable themselves, we don't need to be quite so worried about it. Well, actually, that's not the case. This is just a belt and braces approach for protection of individuals, actually, and the controller will nevertheless still be very much on the hook for compliance with GDPR, whether they are doing it themselves or outsourcing it. And there's a very high level of proof that they would need to show that they are not at all at fault if they wanted to escape liability for failure to comply with the GDPR. And there are various obligations that agreements must have within them from an outsourcing agreement point of view. And I've listed a couple of them, several of them there. And in terms of practical points, what do we have to do next? Clearly, you need to look at your key current data processing agreements with outsourcing organisations and make sure that they are brought into compliance with the requirements of the GDPR. Because that is having the right contract in place is a obligation on both the processor and the controller. Update your standard procurement terms going forward, so that any new organisations coming on board and contracting with you as an authority are going to meet the GDPR requirements. And when you're appointing a processor, make sure that you have done appropriate due diligence on them, and they have been, and they can demonstrate that they're going to be able to comply with the GDPR, and make sure in the contract that what they are being instructed to do is very clearly set out, so there can be no debate about what they were not meant to be doing, and make sure that any liabilities that might flow from a breach of the GDPR are appropriately apportioned within the agreement through indemnities. Another new change, again, bearing in mind that local authorities have been guilty in the past of having security breaches. Often that is how these things come to the attention of the regulator, the Information Commissioner's Office. For the first time, there is now a legal obligation to notify the regulator within 72 hours of becoming aware of a security breach, unless there is unlikely to be any risk to individuals from that breach. And risk, for example, might be that the individual might suffer identity theft or suffer some harassment or discrimination and that sort of thing. There's also an obligation to inform individuals without delay, whereas there is a high risk to their rights and freedoms. Now, ways in which organisations can mitigate this is through strong information security measures. Encryption is a good way of doing that, i.e. rendering data unintelligible where it goes outside the organisation. And that would be a good way of at least possibly meaning that a local authority didn't have to notify individuals if the risk mitigation measures were up to scratch. There would be no risk to the rights and freedoms of individuals. Failure to not meet these reporting deadlines is at the lower level of the fine threshold, so 10% of turnover or a €10 million fine. And by the way, again, the bill will mention this, but this will obviously be levied in pounds at an exchange rate on the day of fine rather than euros. And your data processors, if there's a security breach at a data processing level, they have to tell the controller, the local authority, that they do not have to tell the regulator. So the 72 hours will start upon becoming aware. Either you or you will have the imputed knowledge of your processor. So it's really important that processors are totally tied into these timescales and inform you as soon as possible to allow you to meet your 72-hour deadline. So what can we do to kind of get ourselves ready for this particular aspect? One of the recommended ways is having an incident response plan and making sure that everyone knows what their roles and responsibilities are under that, if and when the unfortunate event ever happens. Make sure your information security systems are easily able to detect breaches and show exactly what has and hasn't been breached. Make sure your records are fit for the purpose. Which individuals do you actually have to tell? If you do have to tell them, are you able to contact them? Are they up to date? And also, as I say, look at encryption and other data minimization measures to keep your exposure here to a minimum, of course, because criminal elements cannot steal what isn't there. So if you're keeping your data in a really good hygienic state, it will mean that hopefully you haven't got lots of out-of-date old records, and therefore there's obviously less less issues to deal with on a breach situation. And then finally, last implication, just highlighting that actually individuals will have much greater rights, certainly enhanced rights under the GDPR, building on the one that we know a lot about, which is subject access requests. Individuals now have the right to require controllers to erase their records effectively if those records are no longer needed, or the individual objects to the processing, or they're otherwise unlawful. There are exemptions, and some of these may indeed be useful for local authorities, for example, legal obligations or public interest or public health. Individuals have got the right to have their data provided to them in a commonly used format, so they can take a copy of their personal data and potentially take them to another service provider. Obviously, potentially less importance to local authorities, but I guess thinking it through, individuals might ask for a copy of their data so they can then provide it to a new authority if and when they move. Subject access requests, broadly the same. Slight change. There's no money-making opportunity for processing the first request anymore, and there is an ability to refuse to, or there is an ability at least to charge if requests become excessive. And there's now a 1 month period to respond. Where local authorities use automated decision-making, the individuals now have a right to appeal if there's an effect on them through that automated decision-making process, and they have a right to require humans to intervene. And then finally, just what to do around this area. Clearly, making sure that you've done data protection impact assessments to make sure that you know exactly what the potential risks are of processing, and with the launch of a new service or a new offering through the local authority, is everyone up to speed with knowing how to respond to requests for any of these by individuals to exercise any of these rights? And I think that is it. So I think I will now hand over to apologies. Just a quick summary of just treat you with this this smiley figure just to summarise the key implications.
So, particular considerations for local authorities in relation to the GDPR. Because the GDPR has certain requirements in relation to public bodies, this will also include local authorities. There are a number of these. One is the fact that local authorities will need to appoint a data protection officer. This is a mandatory requirement under the GDPR. Secondly, one of the grounds for lawful processing, the legitimate interest ground, is not available for public bodies. Therefore, local authorities are going to make sure that where they previously relied on that ground for processing personal data, they have to find another ground to do that. Thirdly, sense that the local authorities have not been the best at complying with the data protection regime we've historically had in place, and therefore, given that history and given the hugely increased ability for the Information Commission Office to levy fines against non-compliant violations, you can expect local authorities to remain very much in the firing line for that sort of regulatory action. Another point, of course, is that local authorities handle a lot of sensitive personal data, and the requirement for processing that personal data in the GDPR has changed slightly, and therefore local authorities don't need to pay to take the And finally, we know that local authorities outsource a lot of their functions because of the way in which data processing is dealt with in GDPR, and the risk profile of appointing a data processor under the GDPR has changed and increased. Again, this is a very legitimate area for local authorities to pay particular attention.
That's great. Thanks, Piers, for that interesting quick overview on GDPR for local authorities. I'm just really going to spend a few minutes now just talking about how we've worked with Piers and the team at Clayden Law to come up with some tools that may help organisations meet their GDPR compliance in time for the Act when it comes into force in May of next year. There are different stakeholders involved in an organisation to achieve GDPR compliance, and those are typically defined into 3 or 4 different areas. Really, the board or the local authority perspective, the leader of the council, the senior executives need to be aware of why it's important, why GDPR needs to be something that they should take some kind of notice of. There is a cost and a reputation of getting it wrong, and neither of which are something that I'm sure that senior members of local authorities would like to have to deal with. And the people within the organisation who are trying to deliver this GDPR compliance will need their support and their buy-in. So there is an education required for the senior people of the organisation to get their buy-in. The next person in the chain is called the practitioner. This is a term that you may have come across as you've been looking around on the internet. It may be one of you on the call today. Basically, this is the person who has the responsibility to make sure the organisation is compliant. It may be a contractor, maybe an employee, a business owner, director, senior manager, could be yourself. But basically, this person has the job to make sure the organisation is compliant. And therefore they need to know everything. They need to know everything relevant to them to make sure that they've actioned everything they need to do and nothing is missed. So they need quite a lot of information, a lot of help, a lot of assistance. The next person along in the chain is typically called the foundation. So these are the people who actually have to do it. So typically somebody takes responsibility for GDPR compliance, and then they will delegate tasks throughout the organisation. Once again, this could be you, could be anybody, and they will typically be delegating to people like IT, HR, finance. It may be that the data protection officer now has been given this job. So somebody that they need to know pretty much everything there is to know about the GDPR, but there's some things they may not need to know about. So, and then finally, it's the staff, the employees, who are really, they've had some data protection training as part of their induction into the organisation. They need to be up to speed. They need to be aware of the basics of data protection, of GDPR, and the changes, some of the significant differences that GDPR is now going to bring to them. And everybody really who works in the business needs to be aware of what's going on, have some basic knowledge. Not only because they need to have that, but as the practitioner who's trying to drive this through the organisation, it's important for you to be able to evidence that your staff have received training and have been trained. So there is quite a big training job, particularly for local authorities who have high numbers of staff across a wide area. So it's quite an important part of the training programme for staff. So the challenge really is what to do, and just there's a lot of information out on the internet. We Googled GDPR back in October, November last year, and there was hardly anything out there. I did a Google on 1st of September, and you can see there's a tidal wave of information out there that's changing daily. UK Data Protection Act law coming in, everything is still changing, and there's a lot of information out there. And it can take an awful lot of time trying to figure out and filter through all the information. You've got classroom training. You can attend classroom training. There are seminars that you can go to, webinars such as this one. You've got the legal compliance coming in from the ICO, where they're providing toolkits and useful information, white papers. There are consulting firms, accountants out there, and lawyers out there, all helping. Basically, there's a lot of information for you to try and find out what you need to find out and make sure you don't miss anything. And the issues are like, where do you start? How do you discover what's relevant? Who do you trust? Are people right? There's a lot of ambiguity out there. People saying this means this, other people saying it doesn't. There's obviously a cost implication of going out to tender or going out to consulting and agencies to get that done for you. But you know, there's a lot of information out there that you've got to plow through to be able to come up with a business plan or a proposition to move forward with GDPR compliance. Well, the good news is, working with Piers and his team at Clayden Law, we've spent the last 3 or 4 months, probably longer, putting together what we believe is a comprehensive package of e-learning online content available through a cloud-based training portal that brings everything together, everything that you need to know in one place. And up to date is quite relevant. Obviously, with the latest change coming out with the UK Data Protection Bill, we've just updated, or in the process of updating our content to reflect that. So it's a bit of a moving feast at the moment, but you can be confident that it's being done with the expertise of a law firm who specialises in this sector. Because it's online, we recognise that if you're going to a seminar or you're going to classroom training, you can actually interact with people and ask questions. Where you do something online, you don't get that facility. So to recognise that as well, within our package, Clayden Law are offering some free consultation as part of our proposition. So you can get the benefit of an online platform, not having to leave the office, and rolling that out to your staff, but you still get some consultation if you need it, just to ask the Clayden Law some questions, clear up ambiguities, any specific questions you may have for them. The reason I talked about those 4 different stakeholders at the beginning is to really to sort of get you thinking about how, when you're trying to train somebody or get information, you need to make sure that the right people have the right information. So we worked with Clayden Law and developed 4 different training packages, which consist of various different modules, if you like, from 1 through to 11. You can see the modules there. And then we would identify that all your staff need to have course 1, 2 and 3, which will be an hour to an hour and a half of online training, foundation and practitioner and board, as you can see, need different modules. So the key thing is that we are tailoring the training and the learning to the people based upon their need and based upon what they need to do. And the full suite, the full foundation, the full practitioner course is actually equivalent to about 3 or 4 days of classroom training. So, you know, Clayden Law have delivered 3 and 4 day training courses, and a lot of the content they would deliver in that classroom session is in the e-learning content. So it's a very rich, package of training. So I'm just going to switch now and to show you.
25th of May 2018, and there is no end of information out there on what organisations need to do to get themselves ready for GDPR compliance. But in this 2-part module, we aim to draw it all together with some practical advice. Part 1 focuses on issues that can be characterised as internal to your organisation, and the next, Part 2, will focus on the outward-facing issues. In Part 1, we will focus on the following topics: awareness, accountability, data mapping, grounds for processing, consent, the Data Protection Officer, DPO, privacy by design and default, and insurance.
Okay, I'm not going to put you through the pain of a slow internet connection, which I'm clearly struggling with today, and we've pretty much run out of time now. We thank you all for your patience. What we'll do is, if you would like to have a look at the e-learning, we will send you a link through, so you can run it at a decent internet speed and get a good feel for what the various different modules and packages provide. So if you want to, we'll send you some information. We'll email you, and if you would like that link, just let us know. We'll send you the link to the webinar. If you do have any other further questions that you'd like to ask Piers or myself at Me Learning, or anybody at Me Learning, please feel free. thank you very much for your time, and apologies again for the technical glitches. Thank you and goodbye.
Thank you.